Good afternoon, everyone. I'm Daphne from the Institute of Banking and Finance, and I'm a host today. We're delighted to be partnering with LexisNexis for today's session on data privacy and cybersecurity. We are also honored to have Mr. Ken Chia, Principal from Baker Magazine Wong and Liao, and Mr. Steve Tan, Partner and Deputy Head, Raja and Tan Singapore LLP, as our speakers today. Before we start the session today, I would like to share that if you have any questions, please post them using the Q&A function found at the bottom of the screen, and the speakers will address them during the Q&A section. If you would like to address your question to a specific speaker, please kindly state so in your question. For those who may not be familiar with IBF, I would like to first give you a brief intro on IBF and our offerings before I pass the time to LexisNexis. IBF was established by the MAS in 1974 as a training provider to provide functional training for the financial industry. Since then, our role has evolved into one of the standard settings of the skills and competency for the sector. We also took on career advisory services, and since 16th October 2020, we are officially appointed as the Jobs Development Partners by the National Jobs Council to proactively work with firms to focus on supporting workers who are in job roles that are being transformed due to the wider adoption of technology in financial services. This is a quick look at our services and how we can support you across training, recruitment, and workforce transformation. You can find out more about our services and connect with us on any one of these areas via our website. The COVID-19 pandemic has devastated global markets, and we are seeing a period of economic contraction. However, this is also a window of opportunity for companies to train and prepare your employees so that we are ready to accelerate growth when we emerge from this downturn. The MAS and IBF are here to support this industry. You may wish to tap on the enhanced training support, which is part of MAS support package to sustain and strengthen capabilities in the financial services and fintech sector amid the current economic downturn. The aim of the enhanced training support is to encourage more training and prepare for the accelerated growth when the threat of COVID-19 recedes and more economies open again. For 2020, we have raised training funding support to 95% for all FTS and STS programs, subject to prevailing grant caps. The funding quantum will be reduced to 90% later this year before going down to pre-crisis levels in 2020. Hence, this is really a good time to look into your own upskilling needs. You can find out more details on the enhanced training support on our website. You can also find eligible training programs on the IBF Program Finder on our website. IBF will further supplement the commercial training available with our free webinars during this period, like the one that you are attending now, to support the training needs of the industry. In addition, you can also tap on Learn at IBF Learning app for bite-sized learning at your own leisure. With that, I have come to the end of my presentation, and I'll hand over the time to Amelia from LexisNexis for a short introduction on LN before she hands over the mic to our first speaker. Over to you, Amelia. Please kindly be reminded to post your questions to our speakers using the Q&A function found in the utility bar of your Zoomed interface.
Sorry, I was on mute. Okay, thank you, Daphne. Good afternoon. My name is Amelia, and I'm from LexisNexis. I would like to share a short introduction of who LexisNexis is and how we support the compliance and corporate legal professionals. LexisNexis Legal and Professional is a leading global provider of information and analytics that enable professionals in legal, corporate, government, and non-profit organizations to improve decision-making and achieve better business outcomes. We are a part of RELX Group, serving customers in more than 130 countries with 10,000 employees worldwide. Across the globe, we combine content, technology, and analytics to advance the rule of law and shape a more just world. LexisNexis focus on providing businesses with comprehensive regulatory and practical guidance in managing companies' regulatory risks. Our portfolio of solutions includes LexisNexis Regulatory Compliance, and as well as Lexis Advanced Practical Guidance. LexisNexis Regulatory Compliance is a legal obligations register and alerting solution that combines regulatory content with technology to empower you to take control of your compliance obligations. We partner leading legal and industry experts to provide a practical, plain language interpretation of all relevant legislative and regulatory materials so you don't have to. Available modules for this includes anti-bribery and corruption, anti-money laundering, cybersecurity, and data privacy across multiple regions. For Lexis Advanced Practical Guidance, it actually provides corporate legal with the know-how and step-by-step guidance to their daily legal matters to significantly reduce the time spent researching and preparing a matter. Guidance content is also available in multiple jurisdictions. To find out more on both solutions, you can click on the links provided in this slide. We are also providing a complimentary international privacy checklist that will be available for download for all attendees. The links will be provided after the webinar. Do keep a lookout for it. Without further ado, I'll hand the time over to Ken Chia, who is one of our leading experts for regulatory compliance, and Steve Tan, a leading lawyer in data privacy and cybersecurity. Over to you.
Great, thank you very much. Just let me share the screen. Okay, hopefully you can see that.
Yes, Ken.
Okay, good, thanks. Okay, so thank you everybody. I see quite a few of you online, and it's good to see everybody in the middle of Chinese New Year. Hopefully, it'll not be virtual next year. So I'm a principal with Baker McKenzie in Singapore, and I'm a member of the firm's IP Tech Trade and Competition Practice Groups. And one of my areas of focus is cybersecurity and data privacy. So me and Steve have a bit of overlap, but hopefully, we have deconflicted ourselves for the purpose of this talk. So what we'll cover today is essentially looking at some of the new key compliance areas. Obviously, cybersecurity is the one I'm going to be focusing on, and also give you an update on the MAS Technology Risk Management guidelines, which were just issued. And then, we'll talk a little bit about cybersecurity cases in Singapore, and then I'll hand over to Steve, who will cover some of the data breach cases for financial institutions, and then look at the amendments to the PDPA. At the end of the session, we're happy to take questions. If you have any questions as we go along, also happy to essentially answer them as I go along, to the extent that it shouldn't be a combined answer with Steve. Okay, so the one of the key compliance areas nowadays, and I note a large proportion of you are from senior management. And across the world, there's been increasing focus on cybersecurity as one of the areas which should be, at least a significant board agenda item, if not one of the more pressing ones nowadays. And as SMS said, at the start of Cyber Week in 2019, it's no longer a technical issue. It's not something you can just say, my CEO will handle it. It is not just a business continuity issue, but it is also a business strategy issue. And if you look at that chart on the left, essentially, the areas where you can just leave it to your CIO or CTO or whatever you call it nowadays, has essentially shrunk. One, there's a lot more things you need to do in terms of corporate investor relations. You need to deal with your HR, because a lot of these will be generated through employee whistleblowing, and that might lead to disciplinary concerns. you would have to deal with any follow-on litigation. So in the US, we have a huge cybersecurity practice, which is essentially focused on white-collar defense. Because the minute you have a cyber breach, it's almost likely that you have an ambulance chaser coming after you with a nice big class action lawsuit. So we do a lot of defense work. Luckily in this country, it's not so much. But then, there are also other areas, things like crisis communications, reputation management, dealing with forensic investigations, etc. So the board needs to essentially, if not build it capabilities in-house, but also understand who you can reach out to for assistance in some of these things. And it's no longer like I said, something which you can just pass on. The reason why it's even more focused nowadays is obviously partly due to COVID. As we've seen in last year, even at the start of COVID, the head of CSA, Cybersecurity Agency, came on, gave quite a lot of talks, both locally and domestic and internationally, talking about the increase in COVID-related attacks. One, just because we're working from home, there's a lot more surface area to attack, essentially. And I was just listening to a talk this morning, saying, you have to start worrying about things like VPN concentrators and stuff like that. Not only just, looking at, what you do in the office. So we don't have the latest cyber landscape, but this is the most recent one from the CSA, 2019. And you can see quite a lot of statistics there. A lot of phishing attacks, obviously, ransomware attacks, but it also, quite a lot of increase in cyber extortion, computer misuse act crimes, and online cheating. And I'm not sure if you can see it, but on the right side, it mentions one of the incidents in the financial sector, which happened in January 2020. Essentially, they had been essentially subject to a ransomware attack by the Sodomiki Wiki ransomware. And then essentially, their systems were locked up until they paid a ransom. And we are currently dealing with quite a few of these. So, I've got one on my table where they started from a phishing attack in the US, moved across to a Brazilian server, and then went to Europe, and then finally ended up in Singapore and took stuff. So at that time, they were still unaware of the extent of the breach, and they thought it was just a ransomware attack. Obviously, a demand for ransom was made, but when they didn't pay, then the people started threatening to expose stuff on the dark web, and information was actually posted on the dark web. And it was only through some of those things that we realized the full extent that even stuff from Singapore has been taken and posted online. But it shows one, the sophistication of these attackers now. They treat the whole world as their playground. Like I said, this started in the US and ended up across Asia as well. And essentially nobody's immune, no matter how sophisticated you are. In terms of the, obviously, the CSA is concerned about what's going to happen at this time. Because of except one, COVID-19, but also for another reason. And it's because, all of us, as a result of COVID, increasingly digitizing our business. If you haven't gone to the cloud yet, a lot of people are moving stuff on the cloud, and even their crown jewels. Everybody's thinking, how do we use machines in place of people? So increasingly we'll see machines taking the role of more automation. We've already launched 5G in Singapore. If 5G comes, the Internet of Things, there'll be a lot more connected devices, and many companies will be starting to use all these things in whether it's controlling their factories or could even monitoring their workforce. And then obviously finally, we have developments in stuff like quantum computing, which could make encryption kind of dead as a dodo if they can, you can use it to unlock computers much quicker. So the, for the board, they need to understand, not only the landscape in terms of what's going on around the world, what the hackers are doing, etc., but also what our laws in the legal regime. We'll come to, like I said, focus on the what MES is doing, but briefly, in Singapore, we have a combination of laws. We have the Computer Misuse Act, which goes after the hackers, the Cybersecurity Act, which essentially addresses owners of critical information infrastructure and tries to harden their IT systems. With the PDPA, which Steve will cover on, which deals with data breaches of personal data. And then, obviously, for people in this sector, Banking Act and other laws affecting financial institutions. I would not be amiss if I didn't mention the Companies Act as well. So there is a provision in the Companies Act which imposes liability on directors. And whether it will be used in the future, because you let things happen on your watch, is a good thing to watch out for. We have had a lot of cases, whether they are hacking cases which have gone Computer Misuse Act like, but even more the PDPC. We'll show you some statistics later on. But the PDPC has gone after many people for breach of protection obligation, which includes breaches of cybersecurity. And then if you are critical information infrastructure, you also are subject to various codes of practice, so depending on what industry you're in. Increasingly, if you're using some of these connected devices, you will have to think about whether or not the devices should comply with the Singapore Common Criteria Scheme, which is meant to give people an easy way of looking at how secure they are how cyber secure their devices are. Then obviously we have guidance from the regulators like the PDPC. So in Singapore, obviously the police does go after crimes, essentially computer crimes, but the CSA also has its role to play in being kind of our national cybersecurity kind of task force, and they are in charge of our cybersecurity master plan. And as a part of that, what they're obviously trying to do is raise awareness. And as a board, you need to understand what the CSA is doing, and be aware of the risk they're showing. So, like I said, some of these examples, there are annual reports, but also there's quite a lot of training materials on board, and obviously they're also pushing the kind of security side of it of devices, etc. And then you have the PDPC, which Steve will touch upon more. And then other sectoral regulators like the MES, which we'll go through, in the next section. But generally, all these laws have common thread. One is to safeguard systems data. What measures they want you to put in place to protect that. Measures to recover and minimize the impact of a breach, through either resiliency, continuity, or recovery, and then obviously transparency through breach reporting. There's also quite a lot of industry guidance. So ABS is obviously one entity in your sector, which does provide a lot of best practices. And then there's obviously, data security driven legislation, laws, etc., which are not just limited to personal data. So banking sector is a good example. If you're a bank, it's customer information. It doesn't necessarily need to be personal information, which is what is covered. And obviously there will be lots of stuff which is, specifically infrastructure driven. So if you are obviously critical player, whether it's a telco or ports or stuff like that, they will be looking at some of these aspects, if your power, for example, as well. Unfortunately for the board, there is no uniform approach across countries. You see very different approaches to cybersecurity and data breach kind of legislation across the region. And sometimes, like in Singapore, a lot of it is sector specific and driven. We have a question, which is how does the company evidence that the board is aware of changes in the cybersecurity landscape and oversight over the company? So obviously one method is to make sure that you do discuss it at the board level, minute it, that you have thought about it. And when we come to these guidelines later, the TRM guidelines, MS just actually imposed quite a lot of things for you to do and tick off. And so what you will have to do is go through the TRM essentially, if you're an FI, and make sure you've done all the things which the MES has said the board should do, and document it. So for a lot of this stuff, what they want to apply, and it's not just personal data; it's the concept of accountability, and accountability requires you to be able to demonstrate compliance. So that was one question. Okay, so the going on, we'll now look at the MES technology risk management guidelines. So they were just recently issued, and the last version was in 2013. Although there have been small updates as they gone along. So obviously it's quite a big jump, and it basically kind of adds on top of what we call the MES notices. So obviously MES notices are stuff which you have to comply with. So in terms of technology risk management, which has got its own breach reporting, but also cyber hygiene, what you need to do to protect your systems essentially. So those are you must do. And the guidelines are a bit softer. They represent best practice essentially. But increasingly, what is the difference between, obviously from an MES point of view, best practices, they do make a statement. This is not meant to be, taken as a standard of care for negligence purposes. But clearly, it is. They do elaborate on the mandatory requirements set out in these notices, like I said, which do carry penalties for non-compliance. So the three broad areas which the new guidelines focus on are essentially board and senior management responsibility. To what extent they have to conduct oversight over the systems and the technology risk management practices. But to cover things like which go beyond outsourcing. So traditionally, if you're outsourced, and if you are subject to banking secrecy outsourcing, then there were a couple of conditions you had to meet before you could do that. You could rely on outsourcing without consent, essentially. These guidelines go further and say, there's other third parties which traditionally you wouldn't regard as IT outsourcing, which should be covered as well as part of your TRM. And then there's obviously a whole pace of rules and guidelines, emphasize security by design, cover the use of APIs, example, and that's essentially to keep pace with current trends in technology development and deployment. So the guidelines are guidelines, but the MES does care and does want to look at the degree observance you have done with the spirit of the guidelines, essentially. So you do have to take these things fairly seriously. Let's move on to exactly what you as the board, for example, will need to do. So firstly, it's no longer kind of amateurs dealing with it in a sense. So what they have said is that the board and senior management should include members with relevant knowledge, including cyber threat risks. They should appoint key technology and cybersecurity staff, i.e. CIO, CTO, CSO, with minimally CEO approval. The board should give senior executives sufficient authority, resources, and access to the board. And in terms of resources, the CSA has said that the government as a whole, over an average over a couple of years, should spend about 8% of its IT budget on security, for example. So you just got to make sure that the people you allow, you task to do all this stuff, you have enough money to do it. The benchmarks in the industry, I would say, not as high as that. I think for banks it's probably about 4%. For FIs it's about 4% generally. So that is half of what the government is actually spending itself on cybersecurity. But what they also expect is obviously not only just having people which know all this stuff, but the board itself should also undergo training to raise awareness on technology risks. And so the question mentioned it, how do you document that? Well, make sure you do document the type of training you do receive at the board level. And obviously, they also want to make sure that you have a bit more than what the general staff have on IT security. So they expect you, not to just sit there and leave it to the CTO anymore. In terms of risk owner, they also say that there should be a risk owner identified who will be accountable for ensuring risk treatment measures implemented. So again, this will provide an additional layer of oversight over technology risk matters at an organizational level by putting specific people in charge of different aspects of functions, for example, or groups of functions. So this is dealt with in section 4 of the TRM. And so, like I said, they do expect not only at the board and senior level, but one level down, maybe a department level, function level, there will also be specific risk owners as well. So that just layers on the levels. The next part of it, like I said, they do want to broaden who's covered within your scope. So as obviously you do have to assess and conduct due diligence on your third-party service providers prior to engagement on an ongoing basis. But like I said before, it does capture services that previously fell out the scope of outsourcing arrangements. So even your people providing IT forensics and penetration testing and even online marketing services should be covered. Obviously some of these people do have quite deep penetration into your network, especially if they're doing IT forensics on yours and pen testing. So clearly, you have to look at all this in much more detail, and that's dealt with in section 3.4. There's also a bigger role for formal vendor assessment when you're acquiring a system. And especially looking at the robustness of their software development and QA practices, and obviously making sure that any vendor access should be controlled and monitored. And even if a commercial off-the-shelf solution is used, there should be adequate mitigating controls in place. And for example, if you do require source code escrow so that you can get access to it, if the vendors are not able to support it, that's also dealt with in the guidelines. There's a whole new framework for security by design. So Steve might talk about privacy by design. We have security by design, and it should be part of the whole system development lifecycle. So each phase, whether it's planning, requirements analysis, design, implementation, testing, acceptance, should have security should play a role at every phase to minimize system vulnerabilities and reduce the attack surface. And obviously, if you need to, you should engage the relevant domain experts. They do make more stress on application software development and management, making sure that any third-party and open source software is used, is subject to review and testing before it's integrated. And they even cover things in a very small paragraph on agile software development, as well as DevSecOps. Now say there's a whole new section on APIs and assessing third-party access, since the number of financial institutions and fintechs, who are using APIs has increased like crazy. So there will be quite a lot of things, like I said, you need to be able to demonstrate that you're complying with, and having all these processes in place, whether it's security by design or making sure that as part of your software development and management processes, you've done all this stuff. Obviously, every in the PDPA, you'll find word reasonable everywhere. In the MES guidelines, the word instead of reasonable is commensurate. That's a different thing. But essentially, there are quite a few kind of changes in there. So, in the first 2013 edition, there were like 4 uses of the word commensurate. There are now 14 users. And it's essentially, to signal MES change in the kind of focus on these areas. So I'll say it's reminding larger service providers, which more systemic importance to the financial system, which obviously carries more hidden risk, to employ commensurate, implementation. And obviously, there's also stress on individuals level as well, having the requisite level of competence and skills in carrying out respective functions. And, essentially, you have to assess your technology risks against your business model, technologies, channels used, and apply those guidelines to a commensurate degree. So that's probably a signal that it's more than what you could get away with under the PDPA as reasonable. And that's the hint there, I think. So the next part of it, obviously, to you, clearly, if you look at SolarWinds, for example, which is a good case, I'm not sure if you read about it, but there was the big attack which implicated, which then spread to Microsoft, to people like FireEye, most of the US government, etc. And it was because the third-party supplier essentially had kind of flaws in the system which could be exploited. And since they were part of every single network, or at least every single major network, there was clearly a big impact on who they could go after through that supplier. I remember one case a couple of years ago, how they managed to get into a good IT company was through their pizza vendor, because you could order stuff which was behind the firewall, unfortunately. And they managed to get in through there and essentially infect their Grab food equivalent. So there are a lot of these type of risks. So you need to know who your third parties are, what do they exactly do. Like I said, are these people behind the firewall because you've got some new policy for employee friendliness, etc., etc. And more importantly, you need to understand how they protect themselves and hence you. Obviously you also need to have a heightened awareness of your own risk, where your information assets, how they be monitored in use and by who, and there are any gaps in coverage and support, etc. So I'll quickly just cover a few things before we move on to Steve. So we are lucky or unlucky that Singapore is used as a case study by the IMF on to what extent we had cyber risk surveillance, how effective our cyber risk surveillance was, these are obviously statistics. MES is not going to reduce any statistics of how many banks were attacked, but this shows kind of a data which refers to the number of cyber attack incidents that occurred in the Singapore financial sector between 2014 and November 2018, which the part of the study looked at. And if you look at it, there are obviously quite a lot of attacks on banks and securities and in capital markets and insurers in that period. Luckily, there's only one case which they reported where there was any direct financial loss, which occurred at a capital markets intermediary. But it shows you, like I said, there are things happening. Obviously, these are the ones which are probably the more significant ones. So if anybody in the bank, obviously you have your log, which shows the number of people who tried to attack you. It's just like, this is the hundreds or thousands a day. For the ones which actually, do actually penetrate, whether or not they get out data is a different question, but who managed to get it. So there's still quite a few cases. No matter what, how good your defenses and robust are. It's interesting though. So I've just given you a kind of a list of the cases which have gone to the PDPC, which resulted in the decision in relation to breach of the protection obligation. And you'll see, unlike the statistics, most of them are actually insurance. Now, that said, most of these are human error, not so much, kind of system cybersecurity type accident incidents. But it shows that, there's still a lot of work to be done by the financial sector. Steve will cover the funding societies case. But, that said, there, like you said, you can see quite a lot of familiar names on these pages, which kind of indicate the extent to which there still needs a lot of work to be done. Now, there are a couple of questions here. Yes, so some of them are quite detailed questions. The easy one, yes, there will be copies of the slides given to you. They will be slightly adjusted depending on what we cover later on. But the rest of it we'll try to deal with in the Q&A. There's one for an anonymous attendee. Is there any out for a small company where the cost of all these tests will be completely out of proportion for their risk and cost? So obviously, they like I said, there's the word, they use the word commensurate. And in the PDPA terms, there's the word, you use the word reasonable. So obviously nobody's expecting you to have the same level if you're a small startup, essentially, as a big bank. But you are in a sector which is at risk and the impact is high. So, you will probably still have to spend much more than Kopitiam, or some small SME who, is doing some manufacturing. Just because you're in this sector, what would be reasonable or what would be commensurate will, be judged at a higher level, require more commitment from you. So it's unfortunately something you do need to budget for and deal with. That said, hopefully, because you're small, the number of customers could be affected individuals be less, but still, that information is sensitive. And Steve will mention to you later on, as long as you have some of this information together with name and RRC number, that will be reportable, even if only one person is affected. So the other questions about, do we need to conduct disaster recovery testing if you're only advisory with software as a service and no payments? Again, that's why, it is, you may be relying on disaster recovery of your SAS provider, actually. But doesn't mean that you shouldn't have your own business continuity measures in-house. You need to deal with all that stuff. And obviously, you would have to do due diligence on your SAS provider to make sure that he's sufficiently safe, essentially. As you heard from Singtel case, Singtel's file sharing system was breached. It was a third-party vendor, but they went in again through SAS provider. So and generally you will be responsible for what your service providers do. So it's important that you do look at, conduct adequate due diligence on them before you choose them. So if you're relying on a cloud service provider, for example, are these people certified under the Singapore multi-tier cloud computing standard? So there are 3 different tiers. You may not be able to afford the top tier, but MAS does expect you to at least pick one of the better ones. But at least the IPCS does give you some degree of reassurance that at least somebody's looked at it and they made certain representations about their cybersecurity. So for that, I'll pass it over to Steve.
Okay, thank you, Ken. Can you hear me, Ken?
Yep, we can.
Okay, excellent. Okay, let me just put on my deck.
Yep, take it over.
All right, okay, let's. You can see my slides, Ken?
Yep, I can.
Okay, excellent. Okay, let me get it going then. Now, just a quick introduction of myself. Basically, I wear 4 hats. I co-lead Rajan Tan's TMT Data Protection Cybersecurity team. In the last 3 years, I've also co-founded and am a director of Rajan Tan Technologies Private Limited and Rajan Tan Cybersecurity Private Limited. Their name suggests what they do. We cover everything from cybersecurity to having an e-learning platform, e-discovery, and so on. My 4th hat is I'm teaching privacy and data protection at the university's Faculty of Law. Now, what has been covered by Ken, and thanks Ken for giving that broad brush, certainly from MAS's perspective and the TRM perspective. What Ken has covered, for example, dealing with lack of resourcing, dealing with, for example, third-party liability, dealing with security by design. You can see lots of that actually being echoed as far as data protection law is concerned. For example, if you hark back to about 2 years ago, the Sing Health case, one of the issues that they had to consider was perhaps the resourcing or the lack of resourcing of the organizations in question in relation to cybersecurity or data protection, right? So plenty of synergy from that perspective between the TRM as well as the expectations of the PDPC. By and large, if you do compliance with the PDPC in terms of the protection obligation, logically you should be some way towards compliance with the TRM and vice versa. But of course, for TRM, there's a checklist. Got to make sure that you do comply with everything. At the end of the day, it's just going to be, unfortunately, it's going to be more costly. I mean, there was questions concerning costs. The regulators don't look at the fact whether you're a small company or not. In fact, some of the startups and the small companies do come into touch with lots of sensitive data. And if you do come in touch with lots of sensitive personal data, that's the key, one of the key criterion that the regulator, the PDPC, will look at in terms of fines and directions that they will mete out against the company. Now, I thought I'll just segue from where Ken last stopped in terms of cybersecurity with perhaps just showcasing one case, right? I've got plenty to cover, plenty of content, so I don't have time to cover too many cases. But I think this one case just perhaps epitomizes what someone or rather an organization, whether you're a big bank, a big FI, a big insurance company, you are transforming yourself, you are leveraging on technology, whether you are upgrading your existing software, whether you're upgrading your platform, your online platform for your customers to use, or whether you're actually considering new software to perhaps power your digitalization effort in order to generate more revenues. You always have to think data protection by design, right? You don't see the concept of data protection by design being expressly stated in the PDPA itself, but data protection by design, as known in the Western Hemisphere, is known by the phrase privacy by design. So whether it's data protection by design or privacy by design, we mean the same thing. Ultimately, it is an approach, a methodology by which an organization seeks to comply with the data protection obligations or the data protection principles. So by and large, if you have indeed practiced data protection by design, and to practice that means that from the time that personal data comes into the possession of the organization, all the way until it leaves the organization or is expunged or deleted, right? You've always thought about data protection principles and always thought about complying with data protection obligations. So that's data protection by design. And this case showcases to you that if indeed data protection by design had been practiced perhaps focused on, then perhaps it wouldn't have happened. So let's take a look at what happened in this case. This is the case of funding societies. Now it is not so well. It's quite a recent case, but I think it's a good case to sort of look at from a fintech perspective and digitalization perspective. So Funding Societies, FS for short, is a very new company. So you could consider perhaps quite almost in the moving from a startup to perhaps a more mature company that operates an online financing platform that connects borrowers and investors, right? So it's essentially is an online platform. Dates are important. On 19 June 2017, FS rolled out new system components for its website. So like yourselves, you could be thinking of rolling out new system components, or you could be perhaps modifying existing software applications or technology through your existing platforms. This rollout actually gave rise to a vulnerability in the website security system. And there are many more cases apart from Funding Societies that showcases this, all right? So something to take note of. So what exactly happened in this case then? Well, a diagram actually paints 1,000 words. So, I took the effort to sort of, draw a couple of, place a couple of pictures or diagrams to sort of make it easier for everyone to catch on, because if not, it's going to be very wordy. So typically when, for example, you're running an online platform, to provide services to a customer, right? A customer is signed on, has an account with you, right? The customer has to log on to the account using a username and password. If everything matches, then of course they can gain access to whatever data is within that person's account. And typically there's only one token that is deployed. But Funding Societies decided to break that up, this one token, into two tokens. You've got the authentication token and the authorization token. Now, I've yellow highlighted the authentication token so that later on in the second slide, you can see when it's yellow highlighted, it's actually referring to the authentication token. So it's easier for you all to sort of remember. And the authorization token. Now, the authentication token essentially is the gate to your house, right? It contains the user's member ID and it grants access to the website. So it is the gate. The authorization token is after you enter the gate, you are then allowed access to your data, right? So what kind of data that the user can access? So that's the authorization token. Now, operating together, these two tokens, and they will share the same, theoretically, they should share the same member ID. They grant the logged-in user access to the website's functions and data from his own member account. Now, however, Funding Society's in-house website developers did not program the website to require both tokens to contain the same member ID. So imagine if a person gains access to the website through the authentication token, right? And then what this means is that this flaw allows that person to look at someone else's data using someone else's member ID, because the authorization token does not need to match with the authentication token. You can already see that is a flaw, right? When a logged-in user carries out browsing activity on a website, the security system verifies that user's authentication token is valid, right? That's what I've just described, and therefore grants data access based on the member ID in the second authorization token, without ensuring that the member IDs in both tokens are identical. So as a result, the member is successfully logged into the website under the authentication token, which carries his member ID, could browse another member's data by changing the member ID in an authorization token. And apparently, there are tools necessary to make such changes. And because these are not sophisticated and were readily available online. And as you had it, actually someone actually did that. So one of the findings, or rather one of the findings by the PDPC in this case, was also about the speed with which funding societies dealt with this vulnerability. So you also have got to think back about your digitalization process, your transformation process, right? If the project manager finds something that is wrong with the system, right? Or if it's already live, but you find something that is wrong, and that potentially could put personal data at risk of compromise, you really need to deal with it very speedily, right? So FS knew about this vulnerability on 7th of July 2017. And of course, as I mentioned, PDPC found that it was slow in fixing the vulnerability. Now, FS got to know about this on 25th July, when a particular individual, let's call this individual the complainant, who complained to the PDPC, he emailed FS that he could extract personal data of 2 other members. So quite swiftly upon being notified about it, FS by the next day, so by 26 July, they were able to fully rectify the vulnerability. So this suggests actually that the vulnerability is one that can be easily rectified, right? So from that perspective, obviously the regulator was looking, right? Why did you then have that vulnerability sort of exist for such a long time? So voila, here. So PDPC noted that the vulnerability lasted for 37 days and placed sensitive financial information of thousands of members at risk. And in italics is from the case itself. This is what PDPC said. The organization did not have adequate security arrangements on their website to ensure that members could only access their own information and perform functions on their own accounts. The decoupling of authentication and authorization of 2 separate tokens was a deliberate design decision on the organization's part so as to enable stateless API development, right? So that's something that I think a lot of organizations in today's world will be thinking about doing in terms of technology, right? Trying to do something new, trying to modify something, right? But you always have to think about the repercussions of that, of doing something, right? So the website should have been equipped with a security measure to ensure that 2 tokens carried the same member ID before granting access to data. And PDPC found that the organization did not adequately test the security of the website. So there are many PDPC decisions that made it very clear that you are expected to always test the security of the website, especially if you have online platform for customer to engage and interface with you, right? And so typically VAPT's vulnerability assessment penetration testings ought to be conducted at least once a year. Note that functional testing is different from security testing, and what is required is security testing. All right. Now, funding societies thereafter was found in breach of the protection obligation and fined $30,000. Now, I know that there are 2 participants who have raised their hands, but maybe we could leave it till the end of the Q&A to sort of ask those questions. Rather than, because there's plenty of content to cover. Collate, keep that thought in mind, and then we'll address the questions that you want to address a bit later on, right? But one key thing to note is that this organization is very young organization, right? And we're talking about a very short period of vulnerability, and this amount of time was actually quite it's quite hefty for them, considering that the numbers of, well, I guess numbers of people weren't that great. We're not talking about millions in that sense. All right, so something to take note of. So with that in mind, let's now slowly move and segue into the amendments that came about and that have come into force as of 1st of February 2021, amendments to the PDPA. Now, the first key one that I want to talk about would be amendments to, that would impact organizations' dealings with data breach, right? Now, so in order to understand it fully, we need to understand what, the context of it. What are we talking about when we talk about data breaches, right? So obviously from PDPC's perspective, it is personal data. But when we talk about a data breach, and especially if you're a financial institution, right, MAS can come after you for data that doesn't involve personal data, right? Because there's what they come after you for would be compromise of customer data. And customer data in the financial industry, in the insurance industry could, is not limited to personal data, all right? So when we talk about data, we're of course referring to perhaps corporate data, trade secrets, customer data, confidential information, employee data, and of course, personal data. I mean, non-exhaustive in this sense, but just giving you a broad brush of, and a diagrammatic overview. And a data security breach can happen in many ways, right? Such as, for example, loss or theft of data or equipment, inappropriate access controls, equipment failure. And while you understand why I go through this, because the amendments do bring into play equipment, all right? Human error, unforeseen circumstances. Now, there are plenty of decisions that revolve around human errors. Hacking attack, cyber attack, ransomware attack, or where information is obtained by deceiving the organization which possesses it. So typically that would be phishing attacks. I mean, there are many cybersecurity compromises where it arises due to a phishing attack. And one good example would be if you do read the Sing Health case, for PDPC, it's about 50, 60 odd pages. If you can't sleep, please read it. I think the Committee of Inquiry report itself is about 150 pages. All right, if you still can't sleep, then read that. So phishing, and it arose from a phishing attack. All right. Now, statistics, we all like statistics, right? So I thought, what is the climate, what is the culture also of enforcement as far as, the PDPA is concerned, right? I think all of us by now, it's been 6 to 7 years since the PDPA came to force in 2014, right? And we know that the PDPC does enforce. But just to give you a quick broad brush, right? In 2017, there were 19 reported decisions. Then there was a leap, right, to 29 decisions in 28, and then a quantum leap to 51 in 2019. It doesn't mean that more organizations were necessarily not compliant. No, it just simply means that perhaps it's a couple of elements. It's either digitalization, that's one. It's perhaps more individuals realizing about the rights they have under the PDPA, and of course, lodging complaints. All right. So thus far, the PDPA has, the PDPC has been proceeding to investigate based on complaints. It doesn't mean that they necessarily they can only investigate if there's a complaint. They can investigate of their own accord as well. But because they have received so many complaints through the years, there's really no, I mean, they don't have bandwidth to, at this point in time, right, really to initiate an investigation, right? And because there are just so many, either there's a breach that is highlighted by the press for which they would investigate, or there's a complaint by a complainant for which they will investigate, all right? And of course, we know now there's a mandatory data breach notification regime for which, okay, these things are going to shoot out of the roof, right? Now, in terms of, we sort of did a quick, count of the published decisions by the PDPC across industries. Of course, the umbrella category of others is the largest. But outside of that umbrella category, if you look at finance and insurance, it's the largest over the last couple of years since 2016. All right. Now, let me then look at section, or rather the protection obligation, right, which is in section 24 of the PDPA, right? And there's actually a reboot arising from the amendments of the protection obligation. Now, we are quite familiar with it, and this is what we've always been familiar with, right? This is more or less the existing language that it was since 2014. An organization must protect personal data in its possession or under its control by putting in place reasonable security arrangements to prevent unauthorized access, collection, use, disclosure, copying, modification, or disposal of similar risks. But there's now a new limb, right? Organizations are also required to put in place reasonable security arrangements to prevent the loss of any storage medium or device on which personal data is stored. So the second focus now is on your laptops, right? Your storage devices, your external hard disk, your handphone, on which there could be personal data, whether of your HR, CVs, appraisals, customer data, and so on, right? Of course, you could argue, what about if it was encrypted? Does it help? Well, arguably, if you look at how the amendments have come about, arguably it doesn't, because the focus is on if that device has personal data, even if it's encrypted, and you've lost that storage device, assuming that you didn't deploy reasonable security arrangements to prevent that loss, voila, you are in breach of section 24. All right. So something to take note of, it requires significant operational changes to deal with this. Now, of course, section 24 is an obligation under the PDPA. And then when we talk about then data breach in question, we're looking at when there is an obligation for you to notify, right, the PDPC or the individual of a data breach. And in order to do that, we need to understand what is the definition of a data breach. Before the amendments came about, right, there was only the PDPC's guide to managing data breaches. And it actually had a very expensive right, definition of data breaches. It was an incident exposing personal data to the risk. So it's not even, arguably, it's not even that there is unauthorized access, but it's exposing, personal data to the risk of unauthorized access. Well, fortunately, it's not kept that expensive, right? Now with the amendments, the new definition for data breach is this, right? But there are two lists. The first is where there has been unauthorized access, collection, use, disclosure, copying, modification, or disposal of personal data. All right, so this is somewhat similar to what you have in perhaps other jurisdictions as well. The second one would be where there is, and this harks back to the section 24, right, new insertion, right, where there has been a loss of any storage medium or device on which personal data is stored in circumstances where the unauthorized access, collection, use, disclosure, copying, modification, or disposal of personal data is likely to occur. So in such a case, if either element is satisfied, then there is a data breach. And why do we know why there's a data? Why do we need to know the definition? Is because there is a threshold upon which certain data breaches are notifiable. So the first step is we have to ask ourselves, what is a data breach? How is it defined? And then the second step in terms of whether we need to notify would be, have we crossed that threshold? Let's now look at what the threshold is. All right, and this is a mandatory data breach notification regime that has kicked in as of 1st of February 2021. And no longer can you sweep data breaches under the carpet. All right. Now, there are two parallel tracks or two categories for which notification arises, the need to notify arises. All right, the first is this, where that data breach results. So, of course, we need to know what the definition of data breach is. Where that data breach results or likely to result in significant harm to individuals. And we have to ask ourselves, what is significant harm? Well, of course, I mean, the holy grail of personal data could arguably be identification number, your NRIC, right? If you only breach one individual's personal NRIC, arguably this is triggered and therefore you've got to notify. Now, under this category, who do you have to notify? Well, you have to notify both the regulator and the data subject in question who has been impacted. But later on, I'll talk a little bit about the data subject because there are one or two exceptions related to that. Now, the first limb is what features also in other jurisdictions, such as where there's a mandatory data breach notification regime, such as Philippines, Europe under the GDPR. But Singapore always prides itself on being the best at what it is, right? So we have an additional limb, right, which doesn't quite feature in a lot of other jurisdictions. If you look at the GDPR, it doesn't appear there. And this is where there's no harm to the individual, but we look at the scale of the breach being significant. In this case, scale means the number of individuals that have been affected by the breach. And here the threshold is 500 or more individuals. So what sort of breaches could arguably be where there's no harm? And well, it could be simply, say, a name list of individuals who perhaps attended an event, right? Of course, one could argue whether the name is BCI, but but of the fact that you attend an event is not BCI, right? BCI being business contact information, right? So that's some information that tells you something about a person, right? That the fact that you attended a certain event at a certain time and date, all right? And of course, whether it's BCI depends on the context in which that personal data was provided in the first place. So if that name list of maybe 501 individuals is perhaps left on the table, is leaked, thrown in a waste paper basket without shredding, then arguably this kicks in, right? And in such a case, the regulator has to be informed. And we do know that if you inform and notify the regulator, they will investigate, all right? Now, what about the timelines? There are timelines in question, right? As far as notification to the individual is concerned. Now, note that notification to the individual is only if there's significant harm, right? But it's subject to exceptions. There is an exception of if you have put in place technological protection measures, such as encryption to their personal data, then arguably you don't have to notify the individual, but you must still nevertheless notify the PDPC, right? And notification to the individual, assuming that the exception doesn't apply, is when at the same time or after you notify the PDPC. So then we have to ask, when do we need to notify the PDPC? Well, notification of PDPC comes in and the formula is as soon as practicable, that's the formula. But of course, they did say no later than 3 days after assessment. So what is this assessment then? Because this 3 days runs from some other formula. This other formula is this, where an event or an incident has happened, and there's reason to believe that a data breach has occurred, then your organization must conduct in a reasonable and expeditious manner an assessment of whether it is a notifiable data breach. Now, fortunately, it is a bit forgiving. It doesn't say that within 5 days, within 7 days, it's reasonable and expeditious manner, but do not push your luck. I would think that, anything longer than 30 days would be pushing your luck, right? If you look at the consultation paper, previously was about 30 days. So I think anything longer than that would be pushing your luck. And of course, this sort of make assessment and coming to that conclusion that there's a notifiable data breach can actually occur on the very same day that you're notified. For example, if there's someone, let's say there's this security company that is that has been searching and doing some research on the dark web, comes across your customers' data on the dark web and notifies you about it, within on say Monday, and within that day you sort of do some random checks and you realize, oh God, it is indeed our data. And then you went to check that, oh, there were certain incursions into your system on a on a certain day, right? And you knew about, and of course you come to the conclusion that, hey, yes, there is indeed a data breach on that day. Then that period is actually not longer period than that day itself, and the 3 days will start running from that day, right? So something to take note of. Put this, bear this in mind, right? I'll now need to move on to the next slide, and this one deals with, one big question people will ask is, what is significant harm, right? And of course, if you look at the personal data protection notification of breaches regulations, it provides you with with a little bit of, or rather, it provides you with a list of situations in which there is deemed to be significant harm. Now, and how they do this is they first state, if you have what has been leaked or compromised, a name, a person's name, or identification number plus either the person's information concerning that the person's HR data, such as wages or salary, or if you're talking about your customers from a bank's perspective, or the number of, or from insurance company's perspective, the number of any credit card, right? Then it is significant harm. Or if there is account number or any private key related to an individual in order to verify the integrity of a secure electronic record, or name plus net worth of the individual, or name plus deposit of monies by the individual, or name plus withdrawal by the individual of monies deposited, or name plus creditworthiness of the individual, or name plus individual's investment in any capital markets products, or name plus existence and amount due or outstanding of any debt owed by the individual. Wow, okay. Or name plus insurance related information. It's essentially any financial information, isn't it? Right? But I mean, I'm not setting it out all exhaustively. Take your time to look at this regulation. Now, there is also one other situation in which they have deemed there to be significant harm. And this is a situation where you're talking about a person's account. For example, the account details for him to log on to conduct internet banking. So if what has been compromised is that that individual's account details, or like, let's say, user ID, and any password, security code, access code, response to security question, biometric data, or other data that is used or required to allow access to or use of the individual's account, straight away, it is deemed to be significant harm. Now, lest you think that why the drafters have presented it as there must be a name or identification number plus something else in order there to be significant harm, lest you think that, hey, does that mean that identification number alone is not significant harm? No, they were just giving you some examples of when there would be significant harm, right? So certainly when you just disclose identification number itself or just biometric data itself, you have significant harm at play, because these are all what we would consider sensitive personal data, and for which in the wrong hands, it could cause significant harm to an individual. Now, arising from all that, right, we know that a breach will happen sooner or later. That means that you have to be prepared. So ask yourself, are you prepared? Right? Do you have a breach response team? You really need to have a breach response team, because if you don't have, then you're not going to be able to deal with a breach properly. Evaluate your security protocols, and that's an expectation, certainly under the TRM guidelines. Establish relationships. What this means is establish relationships with your lawyers, with technical forensic experts. Why? Because when a breach does happen, it happens when you least expect it. It typically happens over weekends or during public holidays. Now, in the last 1 year, I've been activated on 2 mega breaches. Each breach actually covered about 10 countries. So I've had to deal with regulators across close to 10 countries. And if something like this happens, you want to have a relationship such that you don't have to tell you, hey, hang on, I need to do a conflict search. I can only come back to you within the next day, that sort of thing. You want to already have that relationship in place so that, by just contacting them, they're able to work on it straight away. conduct breach simulation so that everyone knows what to do if a breach has happened. All these goes towards mitigation as well, right? If indeed something wrong happens. Has specific employee training on breach response. Again, mitigatory. Regulatory investigation or litigation readiness simply means that please do have documentation in place to deal with data breaches, because if a data breach does happen and there's an investigation by the PDPC, they would obviously, typically one of the things they would look at would be, if you're investigated, do you have policies to sort of arm your employees with knowledge of what to do. So for example, if you look at a guide to managing data breaches issued by the PDPC, they mandate that each organization, they expect each organization to have a data breach management plan, right? And of course, you have cyber breach insurance. All right, so for the last two data breaches, the two organizations, fortunately, they had cyber breach insurance. They could call upon the insurance to deal with that situation. So something to think about. Now, of course, there are enhanced penalties. These penalties have not come into force as yet. So there are two things that have not come into force on 1st of February. One is data portability. The other is this 10%, the increase to 10% of annual turnover of the organization. All right, so watch that space, and as to when it will come into force. But it is, the writing is on the wall, it will come into force. Now, I only have a bit more time to run through perhaps some of the key changes to the PDPA, right? And I'll just very quickly run through them. There's one right at the back, which is actually very important for all FIs in terms of marketing, right? The first one is, wow, there's an increase in terms of, or rather there's a relaxation, right? In terms of situations in which you could perhaps process personal data without consent. And this is a huge exception. It's the legitimate interest exception to consent. Essentially, the elements are where you have a legitimate interest to process that personal data, and that legitimate interest outweighs any adverse effect on the impacted data subject whose personal data you're processing. Of course, in order to rely on this exception, you need to conduct a data protection impact assessment. It's not easy to do that. Check with DPO. Not every DPO knows how to deal with that because this is something quite new. But you can check back with either Ken or myself as to how to go about doing that. And of course, another element is you've got to notify the data subject of your intended reliance on this exception. And of course, you need to keep a copy of the DPIA. Some examples as to use cases for fraud detection and prevention, so on and so forth. I'll just move on because I'm running out of time. But this, copy of this will be provided to you. There's also another exception, right, called the business improvement exception. This exception is a limited exception in that, it deals with where there is you can use existing personal data without consent. So the keyword is use existing personal data without consent, right? Or disclose such personal data to a related corporation. So the disclosure is only to a related corporation where it is for business improvement purposes. And the subcategories of business improvement are these: either to improve or develop new goods or services, improve or develop new operational processes, learn customer behavior preferences, identify goods or services that may be suitable for customers. So a simple example could be, for example, whether it's a Netflix, HBO Plus, Disney Plus, and all this. They deploy a certain algorithm when arguably perhaps they, this is just conjecture, but I would think that that's what's happening. They sort of analyze your preferences in terms of what you're doing, and then later on they will perhaps suggest to you, titles based on what you've previously sort of viewed. Why? Because they've learned your behavior, your preferences, and they will try to put on the plate for you similar type content, right? Now, this exception cannot be relied on to send marketing information. And of course, there are a few requirements before relying on this exception. You must determine that there is indeed a need to for you to leverage on identifiable personal data, that you can't do it through anonymization. Okay, that the processing is one that is reasonable, right? And if you need to share to a related corporation, that related corporation, that both parties are bound by a suitable contract with appropriate clauses. Some business improvement exception examples: train machine learning models, to understand spending habits, so on and so forth. And then there's also an extension of when there could be deemed consent. Now, deemed consent has already been there, right, within the PDPA since 2014, but this expanded it. So now there is deemed consent to cover contractual necessity, and this is where it's reasonably necessary for conclusion or performance of the contract, right? So, for example, if you signed up well, I guess if you do a transaction using, say, an app, right, and this mobile app has you've actually connected the debit card of another bank, so the app could be a Grab app, for example. Then there is deemed consent, right, for say Grab, for example, to disclose that transaction data and your personal data to the bank, right, that was the issuer of that debit card. Right, so that's just a simple example, and of course for that bank to then collect and process that personal data. Deemed consent by notification is a very big exception as well. There's some elements. This is where the organization thinks that there is a new purpose for your existing personal data that you have, or perhaps where you wish to collect personal data on new data subjects, right? So you rely on deemed consent by notification as opposed to express consent, right? And then you conduct a DPIA, a data protection impact assessment, and that assessment comes to a conclusion that there is no adverse, right, effect on the individuals in question. You then need to notify the individual before you actually proceed on processing. You need to give them a certain reasonable period of time to opt out. All right. As to how you notify and all that, I mean that is left up to the discretion of the organization, but usually you've got to deploy a means where it's reasonable to assume that it will reach the individual. And of course, the period of time is also very much dependent on the processing in question and the types of data in question as well. Now, so there's this example. Again, you can read it on your own, because I want to go to perhaps the last couple of slides, which are a bit more controversial. And that we have an impact on perhaps marketing operations, right? But before that, there are new criminal liability provisions to target individuals and not organization or not the company itself. This is where you as an individual, it could be an employee, you knowingly or recklessly disclose personal data that is under the control of your company or public agency to another person without authority, right? Then it is a criminal offense. Or where you as an individual, you knowingly or recklessly use personal data under the control of your company, which results in some sort of gain, harm, or cause loss. Or if your company, the third one is, if your company has actually anonymized some data in order to be able to harness it for other use, you then knowingly or recklessly cause re-identification of anonymized information, well, then that is a criminal offense as well. Okay, so in the past, criminal liability usually didn't attach to employees. Now it does, but of course, there are elements by which are to be met. So it's something to take note of for your employees. Okay, this is the one that impacts. This is probably one of my last slides. That impacts in terms of marketing. You recall in the past, right? Since 2014, right? When we talk about marketing, there are two parts to two buckets for marketing. One would be the non-DNC, non-do not call marketing, such as your email marketing, postal mail marketing. Typically, I would think that most banks, most insurance companies have always proceeded on an opt-out basis, right? And then, of course, the do not call, where it's, of course, obtain clear and unambiguous, written consent, for example, right, by way of do not call. Well, the PwC as of first Feb has said this, and this is what they say. And I think it requires me to actually read it out. Organizations should generally obtain express consent for the purpose of sending direct marketing messages to individuals. Such consent should be obtained through the opt-in method. Example, requiring action to check an unchecked box in order to give consent. The Commission does not consider the opt-out method, example, providing a pre-checked box and requiring action to opt out, as appropriate for obtaining consent for the receipt of direct marketing messages. Similarly, consent obtained using the opt-out method will not constitute clear and unambiguous consent under the do not call provisions for sending a specified message to a Singapore telephone number registered on the do not call registry. All right. So what this means is that it would appear the PwC's position is now this. It's stricter. You can no longer rely on opt-out consent for marketing, and of course you've got to deploy process changes. With that, I will end here. And I think between Ken and myself, we will form, we're part of the panel, and we will take on questions. Between Ken and myself, of course, either of us, we can always answer questions in either category, whether it's a MAS or in relating to the PDPA.
Yeah, so there are quite a few questions, Steve.
Okay.
One or two, then maybe I'll chip in after that.
What happened to the earlier questions?
So they are answered already.
Oh, okay.
Yeah, so there's two tabs. One is open, and then the ones I've answered, I try to answer.
Okay. That's okay. Sherry has asked the question, right? There's the first question for Sherry. Is that right?
Yeah.
Do you want to take that?
The highest impact on the industry, insurance industry. So I thought maybe we'll skip that one. But
okay.
Yeah.
Okay, maybe I'll start
there are
off
a lot of other data breach ones.
Yeah, correct. Okay, let's start off with. I mean, since it comes off the off PTA, let's start off with Stephen's question, which deals with unintended circulation of customers' email addresses considered is it considered a data breach? If yes, is this considered to cause significant harm? Okay. If you all have been following, decisions issued by the PDPC, there have been decisions. There have also been investigations which have not resulted in this, decisions simply because of, the PDPC. Just simply because there's a breach doesn't mean that straight away they issue a decision. They will look at the whole organization in totality in terms of whether you have put in place reasonable measures to inculcate that a culture of PDPA compliance and of course to protect personal data. Now, is unintended circulation of customers' email address considered a data breach? Well, is an email address personal data? The answer is yes. If you disclose an individual's email address, right, without the consent of the individual, then yes, you have disclosed personal data without consent. Arguably, it is a breach. Is this considered to cause significant harm? Arguably, no, because everybody's email addresses, is out there. But that doesn't mean that just because it's out there that in a particular situation that is all right for you to disclose. So something to take note of. All right.
So just let me chip in on that one, Steve. So the only thing you would probably check is that whether or not the email addresses are business contact information.
Yes.
Right. So if it is business contact information, it's not personal data. So, but I'll say if these were all personal email addresses, then you have a problem.
Yeah, actually, my take on that, my view on that is in fact, yes, I'm aligned with you in that if it's business contact information, then the exemption applies. I would still view it as personal data, though. It's just that it falls within the business contact information exemption, but it's a different way of skinning the cat. So it amounts to the same thing. Yeah.
Right.
Okay, so if biometric data of staff is used to physically access a building and that data does it constitute secret? And well, there's actually a lot of questions now being asked about this. Which one do you think we should answer, Ken?
Maybe the last one, the facial recognition. Obviously, there's a lot more examples of that now with all the COVID-19 temperatures.
Oh, okay.
And all that stuff, right? So.
Okay, so well, I think biometric data such as facial recognition, whether your retina image and so on, so on and so forth, and your face image, all that constitutes personal data.
So I think the question is, is this part of the legitimate interest, the new legitimate interest exception or not?
Yeah,
This could be used for security, for example.
Oh, okay. That was one. Okay.
Yeah.
Let me think. Yeah. Go ahead.
A broader legitimate interest exception, and one of the kind of legitimate interests of an organization is to ensure security of its premises, IT, etc.
Yeah. I would say that, typically I would just take a while to sort of think about it, to analyze the factors and elements. Yeah, I would say that yes, it can fall within that. Of course, you need to evidence and do a DPIA. Make sure that it's recorded, kept because if indeed one of your employees, or it could be an employee who leaves the company and then has an axe to grind with the company and then lodges a complaint, that's when you've got to provide a copy of the DPIA and show that you have actually made a proper assessment and it's not just giving lip service. The DPIA must actually go into a lot of different points, right, as to why you're doing this, how you've accessed the risk to the individual, what's your final conclusion, has management, this bit like TRM, has management actually okayed it, that sort of thing. And then finally, the conclusion being that yes, the benefit outweighs the potential for adversity to the individual in question.
Yeah. So then the next question follows on from that. So you made that assessment that you can do it, you've kept it, then there's a breach. So if that,
which question is that one?
Which is the second question. So what happens if you captured it and now there's a breach?
Oh, okay. So I think the key important thing to note is, and which I wanted to also share was, when you rely on these exceptions, these are exceptions to consent. And when you rely on an exception to consent, please note that it is, as the term suggests, to consent. The other data protection obligations will continue to apply, such as the protection obligation. So even though you can rely on a certain exception to collect or process personal data without consent, please take note, depending of course, how sensitive the personal data in question, all personal data must be protected, except if it's business contact information, right? But assuming that BCI is not BCI, some personal data has to be protected to a higher level than others. Certainly when you talk about biometric data, wow, okay, it's got to be protected to a very, very high level. All right. Treat it like, for a bank, treat it like your customer data.
Yeah. But I think the question is also,
and does it constitute a significant harm? Yes.
Yes.
I think I intimated to it already at the start, right? Or rather, not at the start. I mean, in my presentation at the end, when I was talking, when I was going through, the data breach notification obligation, what is considered significant harm. I had a slide there that said that just because in a regulation, they say name or identification number plus, that does not mean that if you just leak identification number alone, it's not significant harm. I would feel that any leak of biometric data, because biometric data falls within the realm of sensitive data, and biometric data, unlike other data sets like passwords, for example, passwords can be changed, but biometric data cannot be changed, right? So your retina cannot be changed unless, of course, you go for a cataract, and then I think it's a glass eyeball and things like that. But I think your retina will still, your retina will still stay the same, because that one is for the glass eyeball. So in the grander scheme of things, anything to deal with health typically, or that is biometric data, if there's a compromise, it is significant harm. Ken, anything to add on your end?
Okay, so I mean, obviously, it's not strictly within that list in the schedule.
It's not, the list is non-exhaustive. It's not meant to be exhaustive.
Yes, correct. So that's the one point, right? But strictly, if you read the list, it's not one of those there in the list.
It's not. I think what the drafters wanted to do was to just come up with a list so that there's no discussion or dispute over whether, if certain things fall within a certain situation, whether it would be significant harm. So my take on it is that, if you're talking about just a leak of identification number, just a leak of of biometric data, it would be significant harm. To think otherwise would be out of sync with how other jurisdictions also deals with that type of data.
Yeah. So what you might want to look at though, so firstly, it's not on the list. So if you look at section 3, regulation 3, so that's this first part, which is 3.1a, which deals with, except name, full name plus certification number plus those individual those details in the schedule. But B also covers another one, which is any password, security code, access code, response to security question, biometric data, or other data that's used or required to allow access to a use of the individual's account. Now, so this is slightly different because now usually we talk about if this was used to unlock your bank account, for example. So, your bank said, okay, you want to get into your account, here, press your thumbprint, and we allow you in. Or we show your face, exactly, will allow you in. So this one is to a building, I presume. Right. So again, it doesn't strictly fall within 3.1b. So then the question is then, do you move on to what, like Steve said, it's still going to be significant because this is the stuff which the PDPC has said before. you can't replace, you can't like cut off your thumb and you put a new bit, or you can't change your eyeball, essentially. So this is a good, interesting question. How the PDPC will merge what you said before with the new regulations.
Yeah, indeed. Do we still have time? I think we've hit the 4 o'clock.
It's actually 4 o'clock. Yeah. Maybe I'll open it, pass it back to Amelia. Do you want to? Do we have time, or do you want to wrap up?
Definitely.
Website. Only for those who have dialed in via the phone, we will have to request for you to send us an email on events@ibf.org.sg so that we can send you the certificate of attendance. You can also access all the QR codes that is being shown on your screen now to get connected with us. The COA will be sent to your registered email within 5 working days. Thank you once again for joining us. Until next time, goodbye.
Thanks, everyone. And apologies if we haven't answered all the questions, but we have a hard stop. So that we don't hold everybody back.
Yes.
Thank you, everyone.
That's
Have
right.
a good day.
Thanks a lot. Bye.
Bye.